And then the other question I wanted to ask you, it sounds like based on some of what you've told us already, you're not just the type of legal writer who just wants to sit in the tower, just give me my keyboard and leave me alone.
Right.
You'll get out there in the fray. You try your own cases, for heaven's sake. So I want to know if you're willing to get in trouble with Jeff and me and sign our petition to abolish Rule 8.1115 and allow litigants to cite unpublished opinions.
I actually don't like that proposal, to be honest with you. So the reason is that I think when judges write unpublished opinions, they're doing so with the belief that well, let's start the other direction. When they write a published opinion, they're thinking about how the opinion will affect the law and affect future cases. So they're thinking about the legal externalities of the opinion. And when they write an unpublished opinion, I think that they may feel more free to decide the case as they see it in front of it, without necessarily thinking so much about how it shapes the doctrine. And I see, if you were to retroactively make unpublished cases citable, it's almost like you risk changing the law in the sense that cases that were previously unavailable in the corpus of precedent are now suddenly part of the precedent. And it could be a pretty significant change. On a go-forward basis, it would be a little bit, less, that concern would be removed if you could only cite unpublished cases after 2022, for example. But to me, it would I think that the knowledge that your justification for your ruling is going to be publicly visible and searchable it has a powerful effect on the on how the judge thinks about the case and how they write their opinion, most importantly. So as long as we're going to have published and unpublished opinions, I think it makes sense to keep the unpublished ones uncitable.
I think that would be a fair proposed amendment.
Mm-hmm.
What do you think, Jeff? That if we were going to change it, then we should still not allow litigants to cite pre-change unpublished opinions, because those are probably written with the intention that they remain in a subterranean body of law that was never meant to jibe with the rest of our precedent.
Second the motion.